What's happening, everybody? I am the other Steve, and welcome back to the House of Kayfabe. And I am, of course, with the man who is calls and all this. I am with your trial chief, Stephen P. New. I read on the internet that you are representing the Tate brothers.
Not those Tate brothers, no.
Okay, good. Whew.
Some other Tate brothers, yes.
Man, you've already got enough heat, brother. You don't need
I
that
oh, I,
kind of
I
heat.
know, I know. I don't need that kind of heat.
Anyone that has a internet connection and a microphone and a camera is playing armchair lawyer with your newest case against the AEW empire. Steve New, what are you doing now?
Uh, Raising a little hell,
That's
causing some good trouble.
checks notes, does check out. So before we go forward, of course, we're going to be talking about your class action lawsuit with the Tate twins, who of course are the boys. And if you watch this channel, you know I'm the biggest Dalton Castle fan, so that hurts me just a little bit. And then it's also going to be talking about the other plaintiff, which is Kevin Kelly. And I want everyone to know that I'm a huge Kevin Kelly mark. If this was the SCOTUS, if this was the Supreme Court, I'd have to recuse myself from this video. So Steve New, Kevin Kelly, the Tate twins. What's going on?
Well, on Friday afternoon in the Court of Common Pleas for Philadelphia County, Pennsylvania, we filed a putative class action complaint. Wasn't just a putative class action count. There were other counts in there as well. What's called declaratory judgment, asking to have the contracts these plaintiffs, my clients, signed as deemed null and void, the arbitration clauses, the no compete clauses, et cetera, and a class action asking the court to certify a class that all current and former AEW talent, both in ring and out of ring, are deemed as employees and not independent contractors. And then some individual counts, both for Kevin Kelly as against Ian Riccaboni and AEW for various things that have gone on. And then for the Tate twins against Tony Khan and AEW for some various things that have gone on. That's the case in a nutshell, Steve.
Now, I want you to explain this to me like I am five. What is a putative case?
Putative class means when you make Rule 23 class allegations and you say that this person can represent this group of individuals, more than 25. For Kevin Kelly, he is the putative class representative for all of the outside the ring talent of AEW. For the Tate twins, they are the inside the ring wrestling talent putative class members. And so I want everybody to understand here at the outset, if you are or were an AEW wrestler or outside the ring talent, you are now a putative class member of this potential class. Now, there's a long way to go. This is going to be a long, hard road, but we got you. We're going to try to do our best for you.
So before we get into that huge can of worms, and for someone who grew up with a union representative as a dad, I know where you're getting at. But before that, what are the claims that you're making against Ian Riccaboni, who's actually also another great announcer, and Tony Khan specifically?
All right. The defamation claim against Riccaboni stems from Kevin Kelly enjoying the movie Sound of Freedom. And he tweeted some about Sound of Freedom. Kevin says that movie moved him and that he liked it. And not long after that, Riccaboni on Discord and others starts saying things that, well, you must be a QAnon conspiracist if if you believe that kind of thing and what have you. So it seemed to Kevin Kelly like that his relationship deteriorated with AEW after this exchange with Riccaboni. Now, we only know Kevin's side of this right now. The reason for the discovery process is to question witnesses and to request documents and that kind of thing. That's the only way that the truth is arrived at, is to go through the discovery process. You request emails, you request texts, you request social media platform information, postings and messaging and that kind of thing, to get at whether or not, someone meant to hurt someone. Was there a reason for, with 9 members of the announced team, that Riccaboni was engaging in the Klingon method of advancement, where you kill off your rivals? We don't know the answers to any of those questions just yet. The only thing I can say, Steve, is that Kelly perceived being treated differently by AEW, by HR, by the people in the home office after this dust up with Riccaboni, and then resulting in that first week of March being let go by AEW, only about 9 months into a 3-year long contract.
And then what was the defamation claim for Tony Khan?
Tony Khan, after the Ring of Honor Supercard here this year, 2024, said of the Tate twins that they were habitual no-shows, and that was the reason why they were being let go. You could imagine, if somebody else says about the Tate twins, oh, they're unreliable, et cetera, that doesn't carry the weight that the owner of the company at a media scrum saying these guys are habitual no-shows to our shows, a statement which is knowingly false. Tony Khan knew that statement was false when he made it. He made it anyway, and the Tates have really suffered since then. So that's why we believe that is defamatory. Now, interestingly, AEW's official position has changed on the Tates, and it was due to financial hardship. We're laying some people off. We're letting some people go. Well, which is it? Is it financial hardship, or was it because that the Tates were habitual no-shows? Truth is an absolute defense to defamation. So if Ian Riccaboni can prove that Kevin Kelly is a QAnon nut, then that is truth as an absolute defense to that claim of defamation. If Tony Khan can prove that the Tates were habitual no-shows and that the travel issues weren't the fault of his own people, Nashville is not Knoxville, folks. They're two totally different cities. One's in East Tennessee, the other's in Central Tennessee. So I think we'll be fine on both those defamation counts, Steve.
Now, defamation suits are famously difficult to even get to trial. Now, I will say this, knowing Steve now for about 5 years, it's like 3 of his favorite words are Marshall football, Ric Flair versus Ricky the Dragon Steamboat, and discovery. And that's what this is about. Right.
But no, this is about justice.
Obviously, we're talking to Steve P. New. We don't. That's like saying that Ric Flair's about the ladies. We don't have to. We know this is about justice. Discovery is the tools in my toolbox to get to there. Let's do a little deep dive on the law there. So can a judge split this up and say Kevin Kelly has a case and the Tate twins don't, or vice versa?
The judge can rule on this. I guarantee there's going to be a wave of dismissal motions right out the gate.
Obviously.
Right out the gate. Just like going on with the Janelle Grant, judge enforce the arbitration clause, send all of this defamation, tortious interference, breach of contract, even the misclassification, send all of that to an arbitration. There are reasons why we believe that would be improper for the judge to do. And it's sort of spelled out in our complaint, but just the uneven bargaining power between the parties here. None of this was explained. They weren't given a copy of the rules. The difference in the price differential, just, either the Tates or Kevin Kelly having to come up with, six figures to arbitrate a case when you can go to the Court of Common Pleas in Philadelphia and for about $400, you're off to the races. That's a huge difference there. So there's going to be an onslaught of dismissal motions. And of course, the judge that gets assigned this can do anything that he or she wants. They can grant some of the initial dismissal motions, none of them. Find that the arbitration provision applies to everything, find that it applies to some things, but not others. So we're just going to have to wait and see how all this plays out.
So let's just theoretically say you make it to a trial. Did you pretty much allude to the fact that Ian Riccaboni is going to have to prove that he's a QAnon member? And that seems like a very abstract concept, because there's I don't know that much about it, but I don't think they have a clubhouse. I don't think they have a building that they all go to. So that seems like a very abstract idea to try to tie onto somebody.
Yeah, except that there are such things as reputation experts. And I've got a really good one in California who will be able to look at what was said on social media and also be able to opine about the negative connotations. Just look at some of the things said about Kevin Kelly today in response to this lawsuit. He was called a conspiracy theorist and a QAnon quack just by virtue of the fact of, him being trending on Twitter and being the headline in this lawsuit, the named plaintiff in this lawsuit. People still believe that stuff. So one of the things that makes the defamation claim a little tougher is the actual malice. There can probably be a pretty straight-faced argument that these plaintiffs are public figures. They wrestle on national television, cable television, so they can at least make that straight-faced argument, because in addition to the four things that you have to prove with defamation about the publication of a knowingly false statement and making it nonetheless, you also, if in the case of a public figure, you have to show that the act was done with actual malice. And that's where Riccaboni trying to knife a competitor in the back for an announcing job, we might just be able to get there on that one.
So it sounds like a lot of this content that is being made commenting on Kevin Kelly is going to end up as evidence.
Yeah. Yes. When my reputation expert finds the tweets in the wake of the filing of this lawsuit, he'll be able to say, well, see here, people believed a lot of what Riccaboni was saying in the fall of 2023 because people are still talking about it in fall of 2024.
This isn't a wrestling question, but it's a law question. If you watch our videos, we have a whole playlist of Stephen P. New weighing in on legal issues that have to do with wrestling. But outside of that, I've been trying to get Steve New to do a law video channel with me because I want to know, something like this. So Steve New, you've been a lawyer for 26 years, almost half your life. And you probably remember a time when tweets weren't evidence. Can you remember right around, and did this have to be, was there a judgment that had to be made that says that these things are now official evidences in cases?
Well, the tweets themselves would not be, but the rules of evidence say that experts can rely on things that aren't in and of themselves admissible, so long as there is a scientific basis to it. That's part of the process of getting that expert through the door, so that that expert can say certain things like see here, I've analyzed the number of shares on social media with this person's name, and it has a negative connotation to, 87% of what you read on the internet about that person since someone said the allegedly defamatory thing has been negative. And so there is a scientific method to it that's employed by the experts. It's not just me standing up there with a flipboard of, Beavis and Butthead
Memes.
rock number one at, twitter.com or whatever, at Beavis and Butthead rock on Twitter. It's not just me standing up there and saying that or showing the tweets. There has to be some scientific method to the reputation expert opining about that.
And of course, when we were in college, we're in college about the same time. I'm sure none of the professors were talking about, hey, you're going to be able to get evidence from social media. Because then we would say, are you a time traveler? There's no social media now.
Right. It was the big thing. I went to law school between 95 and 98, and the internet had kind of, set everything on its head. How do you get website things into evidence? How do you get somebody's GeoCities webpage into how do you get somebody's AOL mail that they might have sent to someone? How do you subpoena that? Exactly. You've got mail. How do you subpoena that? Exactly. It's the same thing. It's just different. It's just fast forward 25 years.
Okay, Mother Jones, let's end this with this, because I think this is going to set up our next video that we have been talking about and preparing for quite some time. I'm so ready to do this video. You said a word, you said collective. Can this case go forward without it being a collective bargained, agreed upon case?
Sure. I heard the people on Meltzer's podcast talking about, this will never work. You'll never get it on a one. Well, yeah, you get a class certified. If we survive dismissal motions and we get a class certified on misclassification, that goes a long way towards building what it is, that I hope that we get eventually, which is a guild to establish for professional wrestlers, part of SAG-AFTRA or something like that. But until that comes along, these type of class action lawsuits is going to be what has to do it. And Steve, I'm not naive. I'm not naive in the least. I understand that Scotty Levy lost one of these against WWE about 10 or 12 years ago in Connecticut. I know that this has been tried before, but I also think that when you look at the 17-factor test under the IRS rules as to whether or not someone's an employee or an independent contractor, the sport of professional wrestling clicks off about 15 out of 17 there. So while I'm not naive, I'm also confident in what Benjamin Bear and I have put together here on behalf of these three wonderful plaintiffs. And let me just say that these guys are wonderful. They didn't ask for any of this. I'm sure that all three of them, all other things considered, would rather be in Milwaukee tonight at Dynamite instead of where they are at home, still under a contract for which they're receiving no compensation or any benefit.
So you pretty much set up our next video where we're going to talk about the guild, and we're going to get into the differences between what a union is and what a guild is. We both come from union households, so that's going to be a good one. Be looking for that in the future. One more thing before we get out of here, because Steve New's got to get out of here, man. These corporations ain't going to sue themselves.
Hey, look, you're proud. Hey, look, speaking of Pennsylvania, I'm channeling my inner John Fetterman here. It's starting to turn fall here in West Virginia. So I had to do my best Fetterman impression for you.
The man of the people, the representation of the proletariat, Stephen P. New. So if you all are real hard internet wrestling marks, Uh, and if you've read the case, there's a lot of black ink on there. Let's go ahead and tell the good people what is in underneath all of that redacted print.
Well, I'm not going to tell them what's underneath it, or I might
Damn
as well
it.
have not redacted it. I'll tell them why it's redacted, not what's under the redaction.
Damn it.
So
He's still
he
sharp at
tried to-
10:30, people.
he's trying to trick me here, folks. As you can understand, these are contracts. It's not the Colonel's recipe for chicken, okay? But it's contracts, and inside of those contracts and inside of the handbooks, they have confidentiality provisions. So until a judge rules either that this lawsuit doesn't have to be redacted, or that the confidentiality provisions in these agreements are also null and void, just like the arbitration and no competes and the other provisions of these contracts, then you will still continue to see those black lines over about 60%. What I will say is all of that is contract language.
Okay.
It purely comes out of the contracts, and I wasn't going to be the one that caused my clients to breach confidentiality in the case that a judge later says, oh, well, the arbitration provision's invalid, but the confidentiality provision isn't. Well, you really screwed up, Mr. New. Okay, thank you, Judge. I'd rather not have to have that discussion with my clients, all other things being equal.
So one more and then we'll get out of here. Will their argument be that the language of their contracts are proprietary?
Oh, no, I don't think proprietary necessarily, just confidential.
Okay. Well, there you go. You can not have to worry about watching anybody else.
I need to make a response. Jim Ross called this lawsuit frivolous. Well, let me tell you something, Bula Bula. This is not a frivolous lawsuit. You're part of the problem. You, Jim Ross, are part of the problem because you fed the guys in WWE as talent relations these crap contracts for a quarter of a century. You told these guys that it was the take it or leave it deal and that they needed to sign these crap contracts that were contracts of adhesion that they should have never signed, or they should have lined the arbitration provisions out of. So I'm not shocked in the least that you go on Conrad Thompson's podcast and you say that this is a frivolous lawsuit. I might lose it, but by God, it's not frivolous. I can tell you that.
It's two people I love so much. I love Stephen P. New, and I love good old JR. He's the voice of my youth. I think that's what happens when you are the office for that long.
Sure.
JR's been office.
Tony Khan's paid JR a lot of money to do nothing for about 5 years now. And so if I were Jim Ross and I were living at Jacksonville Beach and making a bunch of money to not do much at all, I'd probably come out and call Stephen P. New's lawsuit frivolous also. Everybody's got a price.
To Stephen P. New, before we go, I want you all to tell everybody, as an announcer, you love JR.
Well, he's no Gordon Soley, but yeah, he's fought some good matches.
You're so fucking old school. Okay, so there you go, guys. If you all like all
Lance
that,
Russell, but yeah, he's all right.
If you all liked all of that, go give us a like, comment, and share. Go tell your friends about us. I've been so nervous at this because I think that so many people are going to watch this video. Stephen P. New, you will be back, I am sure, to keep us abreast of the situation. I can say,
I hope it's with good news, but like I said, I'm not so naive. Only idiot lawyers would talk smack or try to predict what a judge or what a jury might do. I've been doing this a long time, Steve, and I've won cases I should have lost. I've lost cases I should have won. And all I know is that I believe in my clients and I believe in this cause. I believe that wrestlers have been misclassified. I believe that they've been controlled for a long time, like employees, without having the benefit of being employees, like the Social Security, like the Medicare, like the everything else that comes along with being an employee. And so we'll see where it goes.
I'll sign off with this. I can testify that his heart is pure, right? Stephen P. New is an earnest, good faith actor. And I will say he's a good, honest, earnest, good faith actor with a whole group of performers who have not had a lot of that in their corner over the years. Because I think that even if you're against unions or for unions, I think it'd be very easy with just a cursory knowledge of wrestling to know that the power imbalance has always been tipped towards the office ad nauseum until the end of time, from Frank Hackenschmidt or whatever his name was to now. So as a 1099 worker for the last 16 years, I can tell you that the things that they have to abide by, I don't have to abide by. In my 1099 agreement, I don't have to show up if I don't want to, and they can't do anything. You know what I mean? So that we'll get into that in the next video. Stephen P. New, thanks for taking time out of your busy, busy day. And I will see you next time, brother.
All right. Sounds great. Thanks so much, Steve.